Okay. All right, great. We are now live streaming this hearing. We're here in the matter of the state versus Kanashane Wall.
Keishiana
Wall. And here for the state is Senior Assistant DA Cheryl Freeman. Ms. Wall is choosing to represent herself. We had a very lengthy conversation on the 16th day of September. Lengthy conversation, and Ms. Wall still believes that it's in her best interest and that she's able to adequately represent herself. Is that still true?
Yes, ma'am.
Okay, and in an abundance of caution, we have Senior Public Defender Camille Reddick in the event that some assistance is needed in this matter. And then Officer Elise is here for the state. I'm Judge Dallas. I'm sitting by designation of the Superior Court of Clayton County. Let me go ahead and swear Officer Elise in and swear in Ms. Wall as well at the same time. I need you to both raise your right hand. Do you swear from the information you give, any testimony you provide in the matter of the state versus Kanisha Wall is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. All right, so Ms. Freeman, your witness.
Thank you, Your Honor. Officer, please tell us your name and how you're employed.
Good morning. My name is Officer O'Lees with the City of Riverdale Police Department.
How long have you worked with the City of Riverdale Police Department?
I've been employed with the City of Riverdale Police Department since December of last year.
Officer, were you working on August 27th of 2020 around 6:35 p.m.?
Yes, ma'am.
And on that particular day, were you dispatched to 874 King Road, apartment 9 in Riverdale, Georgia?
Yes, ma'am.
Why were you dispatched to that location?
I received a call in reference to a disturbance.
When you arrived at that location, who did you meet with?
When I arrived at the location, I met with the complainant, Ms. Eason, who was sitting in her vehicle waiting for police.
Was Ms. Eason the person who called the police?
Yes, ma'am.
And is this Sherry Eason?
Yes, ma'am.
Did you speak with Ms. Eason while she was still in her vehicle?
Yes, ma'am.
What did she tell you it happened?
Ms. Eason stated that when she entered the apartment, her and her roommate, the person she was leasing the apartment to, got into a physical altercation. During that altercation, she ran out the apartment to call 911 to get assistance.
And Officer O'Lees, you were breaking up just a little bit, at least on my end. I heard you either say that she was leasing or something like that. Was Ms. Eason leasing the apartment to Ms. Wall?
She stated that she left the apartment, so she was subleasing to Ms. Wall for the time.
During this time, was Ms. Wall the only person who resided at the apartment?
Miss Easton stated she still had her belongings there and she would be at the apartment from time to time. But for the primary part, Miss Wall was the resident.
Okay. What did Miss Easton indicate that prompted her to call 911?
Miss Easton stated when she went to the apartment to grab her belongings, she stated she was moving out. Miss Wall began attacking her. Miss Easton stated that Miss Wall punched her in the face, scratched her, and bit her lip.
When you arrived there, Officer O'Lees, were you able to see any of these injuries?
Yes, ma'am. As soon as I arrived at the scene and I spoke with Miss Easton, I realized Miss Easton's lip was hanging to the point where she had to use her hand to hold it up. So I immediately called the medics and they came to evaluate her and they advised her that she needs to be to treat.
But you're breaking up. Say that one more time. When the medics saw her, yes.
The medics advised her that she needed to be hospitalized to treat the injury. Miss Easton decided to take herself to the hospital instead of riding on the ambulance to avoid an ambulance charge.
Was she bleeding?
Yes, ma'am.
when you say that her lip was hanging down, and I guess I want to make sure that we understand it wasn't just swollen. It was. Could you see her teeth?
Yeah, I could see the teeth and the indentation. It was hanging, and you could see all the bite marks. So the skin wasn't put together.
You could see actual bite marks on her lip?
Yes, ma'am.
And how did Miss Eason state that this injury occurred?
She stated that when she alleged that Miss Wall attacked her and bit her in the lip.
Was anyone else at the apartment at this time?
No, ma'am. It was just Miss and Miss Wall.
Did Miss Eason have any other injuries to her body?
She just had scratches on her chest area.
Was Miss Wall still at the apartment when you got there?
Yes, ma'am.
What was Miss Wall doing when you arrived there?
When I arrived to the apartment, Miss Wall, she really wasn't doing anything. I'm assuming she may figured that the police was on the way, but we knocked on the door. She opened the door, and what transpired was she then stated that Miss Eason texted her, letting her know she was going to the apartment to throw out the rest of her books. In fact, which means she was going to try to evict her out the apartment.
Were you able to confirm that, I guess, that the leaseholder was Miss Eason?
Yes, ma'am. The Miss Eason's driver's license stated her address.
Did Miss Wall make any admissions regarding biting Miss Eason's lip?
Miss Wall informed me that she doesn't know how Miss Eason's lip got to the point that it was that it bit Eason's lip.
You're going. There's like, and you're not moving, so I don't know if it's the connection that you have or what.
It might be the connection. Right now, I'm at City Court. I'm in an office. This is probably the best connection I could get.
Okay.
Okay, you were breaking up a little bit. If you can just start over. Oh, wait, I hear an echo now.
Can you hear me okay now?
Yes. If you can repeat or start from when, I think the last part that I was clear on when I asked you about what was Ms. Wall doing when you arrived there?
When we arrived at the apartment, Ms. Wall opened the door. We asked her what transpired. She let us know that Ms. Easton sent her a text informing her that she was going to throw her belongings out the house, in a sense, evicting her out the home. So Ms. Easton stated when she came into Ms. Wall stated when Ms. Easton came into the apartment, she knocked the salad out of her hand and began destroying her items, which led to an altercation. And Ms. Wall alleged that Ms. Easton had a blade.
Did you find a blade?
No, ma'am.
Okay. I believe I'd also asked you, were you able to confirm that Ms. Eason was the leaseholder of that apartment?
Ms. Eason's driver's license had the current address on her driver's license, and she stated that she had been living there for some time.
And I know I asked this before, but I can't recall if you were breaking up some, but did Ms. Wall make any admissions regarding the injuries to Ms. Eason's lip?
No, ma'am. Ms. Wall stated that she did not know how Ms. Eason had that injury, that she did not bite her on the lip.
After you spoke to Ms. Wall and Ms. Eason, officer, what did you decide to do?
Myself, along with the other officer present, we decided to arrest Miss Wall under aggravated battery due to the nature of the crime. When we attempted to arrest Miss Wall was not complying. We had to tell her several times to put her hands behind her back. Miss Wall continued to not comply, so we also got Miss Wall on obstruction. Then when she got in a patrol vehicle, she began kicking the doors and attempting to damage the vehicle.
Was Ms. Wall saying anything while she was not being compliant?
She was just stating that she didn't understand why she's being arrested. And when she got into the vehicle, all she was doing was screaming. I couldn't make out as to what she was actually saying once she was inside the vehicle.
What type of language was Ms. Wall using when she was in the vehicle?
She was using profanity. We asked Ms. Wall, is there anything in the home she would like us to take? She wasn't trying to speak to us. She just kept using profanity.
You stated that Ms. Wall was kicking when she was in the vehicle. Was anything damaged?
No, not to my knowledge or the other officer's knowledge.
Okay. Did all of this take place in Clayton County?
Yes, ma'am.
Thank you, officer. I have no further questions at this time.
Okay, Ms. Wall, you have an opportunity to cross-examine Officer Elise.
Yes, ma'am. Good morning, Officer Elise.
Good morning, Ms. Wall.
Why did you not allow me to explain what happened prior to putting me in handcuffs?
Ma'am, we gave you plenty of time to explain as to exactly what transpired.
Why did you not allow me to write a statement about what happened?
When we arrived at the precinct, you were informed that you can write a statement. However, when it came time for me taking you out of handcuffs, you began cursing me out along with the other officer.
Do you recall me why you let the male officer take me out of handcuffs and requesting
He never took
email?
Ma'am, he never took you out of handcuffs. We never got to that point. You wouldn't allow us to take you out of handcuffs. I was going to take you out of handcuffs myself, so you would feel more comfortable.
Ma'am, do you have that on video?
Pardon?
You have that on video?
I'm sure he has it on camera. I don't have it on camera.
So you don't have the evidence present today to prove what you're stating?
As far as your interaction with him, it was recorded.
So you didn't record anything, only he was recording?
Not at the station, ma'am, no.
So you are admitting that you did not record from your perspective what happened at all?
At the scene, yes, but once we got to the precinct to do all the proper documentation, he was recording.
So do you guys have that recording today?
Yes, the recording is available. However, I do not have it in my possession.
Okay. Is Officer Plummer here today?
No, ma'am.
Okay. Why wasn't Ms. Eason arrested?
Due to the nature of her injuries, the jail would not accept her. And via the medics, they stated that she needed to be hospitalized. So that's why she was not arrested. That's why I put a warrant out for her arrest.
Why didn't you have the medics assess my injuries?
Ma'am, we asked you if you needed to see the medics. Instead of speaking to us, letting us know that, you wanted to be belligerent. You cursed us out. You weren't being cooperative. After you told us your story, after you got in handcuffs, it was a different situation.
You have a recording of that?
Yes, ma'am.
Okay.
Everything was recorded.
Why didn't you ask Ms. Eason to step outside her vehicle?
Step out her vehicle to do what exactly?
So that you could better assess her injury.
That's not for me to assess her injuries. That's for the medics.
So you're admitting that you never asked Ms. Eason to step out her vehicle?
No, the medics asked her to step out the vehicle. They assessed her.
Were you present during that?
Yes, ma'am.
Okay. Are you aware that Miss Eason lives in a 3-bedroom townhouse on Flint River Road and that me and her do not live together at all?
No, ma'am. I don't know. The only address that I know for Miss Eason is the address that the incident occurred.
Okay, so Eason ever really went to the hospital?
I'm not sure.
Why didn't you all search Miss Eason's car for a gun?
It was never stated that she had any weapons.
So you're unaware that she keeps a gun in her glove
I'm going to object at this point. It's not relevant.
It calls for speculation.
That's fine.
Thank you, Ms. Wall.
So are you aware that Miss Eason was subleasing me the entire apartment?
Yes, she did state that she was subleasing the apartment to you. Not the entire apartment, but she said she was subleasing the apartment to you.
Yes, ma'am. Did you look at the text message that I told you that she sent when I sent?
No, ma'am, because when we tried to talk to you, you weren't trying to show us any proof of a text message. You did tell me that she came there to throw your belongings out. And based off what the dispatcher said, that corroborated with your story.
So you have recording that I never tried to show you the text message?
You didn't show me any text messages. No, ma'am. You just verbalized what transpired. I asked what happened. And you told me that Miss Easton texted you, letting you know that she was going to come to the apartment and throw your belongings out. I think you mentioned that she texted you 30 minutes prior to her coming to the residence. And based off what was dispatched to us, it let us know the same thing that Miss Easton stated, that she wanted someone to be removed out of her home.
Okay, so could you all say that she and her were roommates inside the house?
Yes.
But why did you say that? We were roommates. We're not roommates.
She stated she had still lived there. She still had her belongings there. She stated she was not always present at the home, but she still lived there.
Although she was subleased.
Yes, she stated she still lived there. She didn't stay there for the majority of the time. However, she still had her belongings in the house.
Okay.
And it was very evident that she still had her belongings in the house.
Do you have me on video kicking the inside of the doors inside of the police car?
No, ma'am. You were inside the car. So
if I was inside the
maybe there might be a recording in the vehicle. However, as far as my body camera seeing that, I was unable to.
So how can you say that I was doing that if you never saw it?
I heard it from outside the vehicle, ma'am.
So
me along with several officers that were present at the scene.
So you could hear me kicking the vehicle, but you couldn't understand what I was saying?
No, ma'am. I could hear the kicks, though.
Do you recall me asking Miss Easton, yelling from the police car, is she ready to...
Pardon, can you repeat that?
Do you recall me yelling from the police car, asking Miss Easton, is she ready to take a drug test?
Is she ready to what? I cannot hear you.
Drug test. Do you recall me asking Miss Easton from the inside of the police car, is she ready to take a drug test?
No.
Okay. Are you aware that Miss Easton sells crystal meth?
What? I'm going to object at this point. This is not relevant.
Okay. No.
It's not relevant.
I think, hold on. Not only is it not relevant, it assumes facts not in evidence. So there's nothing here that indicates, Ms. Warren, you can only cross-examine the officer as to what she saw, what she heard, what she has knowledge of. Anything else that caused her to speculate, you can't ask about anything else like that, okay?
Yes, ma'am, no problem. What was I about to ask you? Do you recall being at Laurel Point, Miss Officer Elise?
No, ma'am. I don't know where Laurel Point is.
Because I had requested a police report that you were the officer when I got robbed at Laurel Point, which is how I ended up living at.
I'm going to object again. She's going into something that has.
Yeah, she stated that to me before, and I told her I don't know who the officer is.
1 second. Now, Ms. Wall has an opportunity. Let me explain something. This is the state putting up their case, and then after you can make a statement or you can present evidence that supports your case. So to cross-examine Officer Elise, you can only ask her something that she knows about.
Yes, ma'am. No problem.
Thank you.
Okay. Officer Plummer came up to the car and asked me, did I want to get out the car and get my debit card and my cell phone? And I said, yes. Why didn't he allow me to?
When he asked you where your belongings were, I don't remember him asking you to get out the vehicle to get your belongings. He asked you, where are your belongings, so he could bring it with you to the jail. Well, I was going to transport you. At first, we were going to go to the precinct. However, instead of telling him where your belongings were, you got very belligerent with him.
No, I told him I don't know.
Okay.
Why did you all force me to leave the door unlocked?
Pardon?
Why did you all force me to leave the door unlocked?
We didn't force you to leave the door unlocked. We gave you an opportunity to tell us where your belongings were, and you didn't tell us. As far as the keys.
Nike bag on the chair.
But Miss Eason made sure the door was secured. Before we left, the apartment wasn't left unlocked.
Do you all know where my personal belongings are at this moment?
That would have to be discussed with the apartment complex. I wouldn't know.
You have no idea where my things are.
No, ma'am. You'd have to discuss that with the apartment complex.
Okay, are you aware that I was screaming, I'm being robbed? When we walked out the door, I wasn't cursing. I kept saying, I'm being robbed and being robbed. They're robbing me.
I've never heard that. No, ma'am.
All right. Why did Officer Plummer kick me in the back of my right leg over and over again?
Ma'am, I have no recollection of that.
Yes, ma'am. Why did you take your arm and squeeze this arm as tight as you can when we arrived to Clayton County Detention Center, my right arm?
Ma'am, I did not squeeze your arm.
Why did you unsnap my bodysuit when we arrived to Clayton County Detention Center?
Ma'am, I did not unsnap your bodysuit.
Why did you kick me in the right leg, lower calf, when we arrived to Clayton County Detention Center?
Ma'am, I never physically assaulted you.
Why did 5 police officers have to come out and tell you to stop hitting me?
No officer had to tell me that, ma'am.
So 5
I had to do a ramp call due to how you were behaving.
So once the officers came out, why did you lift my arms over my head and almost show my bare breast to 5 police officers?
Ma'am, I never did that.
Is that on video?
Yeah, I'm sure Clayton County Jail has video surveillance of that.
Yes, ma'am. No further questions.
Okay. Does the state have anything else, Officer Elise?
No, Your Honor, state rest.
Okay. All right. So now, Ms. Wall, it's your opportunity to put your case up. And so that can involve you making a statement. Is there any particular order that you want her to go in, Attorney Freeman, or what is your?
If Ms. Wall doesn't have any witnesses, if she wants to make her statement, I'm fine with that. If she has a statement that she wants to make, and then I'll make my closing argument.
Okay. All right, Ms. Walls. So now this is your opportunity to make your statement.
Yes, ma'am. Good morning. My name is Keishiana Wall. Basically what occurred is Sherry texted me a text message probably 5 minutes after me entering my home from coming shopping from South Lake Mall. She stated to me that she was on her way over to throw all my belongings out of the house. She said that if I had changed the locks, which I did not, she was going to cut the lock off the door and throw my belongings out. I texted her back, please do not come over. At the time I was practicing social distancing. I told her that I was going to be out by the 1st. Because I had paid my rent up until the 1st of the month. It was the 27th of the month. So I have no idea of why she wanted to come over on the 27th and throw my things out of the house. However, what I would like to say is that I was sleeping with her boyfriend, and she knows that. Also, so when Miss Easton came over, she unlocked the door and walked in. I was standing in front of the door. I asked her to please leave the property. She knocked my salad out of my hand. I went and sat down on the chair. She came and stood over me. She said, I don't care about those text messages. I said, Sherry, please just leave and go home. I'm just trying to move out on the 1st. She walked to the back of the apartment to the master bedroom where all my things are. And she began to destroy my business merchandise. I have acrylic merchandise all over a vanity set. She began throwing the acrylic up in the air. I said, Sherry, please, please stop. That's my business merchandise. She attempted to attack me. She split my lip open. When we watch the arrest video, you might can see it and you might not. I did ask them to take pictures of it. She split my top lip open with a blade down the middle of my lip. I am disabled from the right arm down. I had no other defense but to block her. At the time, it happened so fast, I really didn't recall biting her. They said I did. I haven't seen Sherry. I have no idea of what occurred because the incident happened so fast. Sherry threw a vase at me. I moved out.
She threw what at you?
Vase, a glass crystal vase. I moved out of the way. The crystal vase shattered. She attacked me. We fell on top of like a bed frame. The bed frame is broken when you come into the house. I had no other defense of getting Sherry off me.
Keep going.
So once Sherry got up, said, Sherry, please leave. She said, okay, Shawnee, and walked out the door. I looked out of the window. I saw her sitting in her car. I noticed that she left her car keys in the bedroom. I opened the door and threw the car keys. They landed in the grass and shut the door and locked it. Sat on the couch and waited for the police department to enter. When the police department came, I was extremely respectful. I opened the door. I had the opportunity to run. I never fled the scene. When I began to talk to them, they told me, tell me what happened right now. I said, sir, I'm trying to tell you. And then I said, they became like, they were very aggravated and angry with me, yet they were extremely calm with Sherry. I said, well, sir, you can come in the house and assess the situation for yourself. They came into the house. I brought them to the back. I showed them the shattered glass, the broken bed frame, the nail acrylic thrown all over the place. He said, ma'am, do you have an ID card? I said, yes. I walked off to get my ID card. He said, allow me to get the ID card. I picked up the cell phone. When I went to show him the text message, he threw me into handcuffs. I said, why am I being arrested? Why are you putting me in handcuffs? And then I was like, sir, can I at least take my wallet with me? I never resisted arrest. I just constantly said, please allow me to take my wallet, because all my money was on my debit card and all the proof of this incident is on my cell phone. I said, can I please take my cell phone? Can I please take my wallet? Sir, why can't I take my cell phone? Why can't I take my wallet? He just continued to arrest me. So I just began to yell that I'm being robbed. Then I started asking Officer Elise, do you recall being at Laurel Point? To give her some type of regulation. Like, I don't understand why they treated me the way they did. He started kicking me in the back of my leg repeatedly. He walked me out of the door. He leaned me up on the car for like a long period of time. He aggressively just kicked me in the back of my right calf. And he opened the door. I was yelling, you're hitting me. Stop hitting me. You're hitting me. Stop hitting me. Stop hitting me. You're hitting me. That's what I'm yelling. She opened the door. They put me in the police car. I started asking Sherry, is she ready to take a drug test? Are you ready to take a drug test? I started asking Officer Elise, do you recall being at Laurel Point? I was not screaming profanity. Basically, like, he came up to the door, he opened it. He said, where are your belongings? I said, sir, I don't know. Can you just let me go in there and get my wallet and my cell phone? He said, yeah. I turned my feet out to leave the car. He tried to slam my leg to the door. I turned back around in the car, in the door, and walked off. That's really what happened. When we got to the police precinct, they walked me in. I was in handcuffs. They had me sit there. He kept on, he lowered himself down and like had his hand balled up in a fist motion and ran up towards me. I said, so you want to hit me, sir? He stood up and then he went back and sat down. They typed some things up on the computer. He started telling me that me and Sherry are going to family court. I said, sir, we're not going to family court. Sherry and I are not related. He says that I was like obstructive because I said I'm not going to family court with her. He asked me to stand up. He told me to turn around. I said, sir, why are you wanting my handcuffs? Then I looked at Officer Elise. I said, why don't you take my handcuffs off? Why do you keep letting him feel on me? So then she refused to take them off. They had me sit down and they never took me out of handcuffs. They never allowed me to write a statement. Then on the way leaving, I said, ma'am, can you at least take me to Clayton County Detention Center? Like, why do you keep forcing me to ride with the mail? She got an attitude, but she did, however, take me to Clayton County Detention Center. On the way there, she ran the wet red light. A car almost hit us. She began slamming on brakes aggressively. I started laughing. I mean, I don't know what else to do. I'm in handcuffs in the backseat of a car. We arrived to Clayton County Detention Center. She asked me to get out the car. I got out the car. She started yelling at me. I was like, what do you want me to do? Walk where? Because they were hitting me. I don't know what to do. I've never been to Clayton County Detention Center. She aggressively put her arm into my arm like we were going down an aisle as if a married couple. She squeezed as tight as she can. I'm disabled on this arm. I have like a knot from it. It goes numb. She squeezed it as tight as she can and walked me up to the door. Once we got to the door, she turned me to face the door and she just began kicking me in the back of the leg and trying to slam my head on the window. I started yelling, don't hit me. Don't slam my head on the window. Don't hit me. Don't slam my head on the window. She unsnapped my bodysuit and began to roll up. 5 officers came running out of the detention center, and when she turned, then she stopped hitting me. She turned me towards them and began to lift my arms over my head with my shirt raising. I started yelling, don't show them my breast. Don't show them my breast. I had to yell it several times for her to put my arms down. So then the officer told her to step over here and told me to step over there. And that's what happened.
All right. So the state is going to have an opportunity to cross-examine if the state chooses.
Thank you, Your Honor. Ms. Wall, and I just want to be clear, you don't remember whether or not you bit Ms. Eason's lip or not?
We were fighting. I can't tell you like exactly how I defended myself. If I bit her, I probably did, but it was in self-defense. She also split my lip open.
When the police arrested you, do you remember not being compliant when they tried to put the handcuffs on you?
I was never non-compliant. I did everything they asked me to do, ma'am.
When you were in the police car, do you remember yelling out obscenities and kicking inside the patrol car?
I never kicked inside of the patrol car. I wasn't out obscenities. Honestly, I yelled out, please don't touch anything inside of the apartment because it's federal evidence, because I have other lawsuits going on. And I was yelling that I don't want them to destroy my lawsuit documents. I also had mortgage paperwork inside the house, birth certificates, social security cards, bank cards, and legal documentation for lawsuits.
Judge, I think that's all I have for Ms. Eason, but I will recall Officer Elise.
Ms. Wall.
I'm sorry, Ms. Wall.
All right, you're going to recall Officer Elise?
Yes.
Okay, and because the state is recalling Officer Elise, Ms. Wall, if you have any other questions based on what the state recalls Officer Elise to say, you can cross-examine her as well. All right, so that's your redirect of Officer Elise.
Thank you, Your Honor. Officer Elise, when you arrived at the scene, did you see any injuries to Ms. Wall?
Yes, ma'am. Ms. Wall had a cut above her lip.
Wait, you were breaking up. Say that one more time.
Ms. Wall had a minor cut above her lip.
And when you say minor cut, can you describe what you mean by that?
Probably a hairline. not a hairline, like a piece of hair, like just like a minor little cut, like grazed with a nail.
Did you see any blood on Miss Wall?
Just right above her lip.
When you went inside of the apartment, can you describe, I guess, how the apartment looked?
Okay, when I entered the apartment, there was trash on the. She stated that Miss Eason knocked out the salad out of her hand. I saw about 2 pieces of lettuce on the ground. She walked me, an officer, a plumber, back to the back room. She showed me the bed frame. It was a bed frame. There was no bed present. She showed me her acrylic items, and she stated Miss Eason began destroying her acrylic items. There were stuff scattered all around the sink in the bathroom that had her acrylic items. As far as a broken vase, I did not see any pieces of glass. There were clothes around, and that's about it as far as belongings in the apartment.
And also, Elise, you were questioned by Ms. Wall and heard her in her statement indicate that how you allegedly handled her when she was arrested.
Yes, ma'am.
Can you walk us through from what your part was when you arrested Ms. Wall?
My part for arresting Miss Wall is when we left the precinct from Riverdale Police Department, put her inside my patrol vehicle. We drove to the Clayton County Jail. Once we got to the Clayton County Jail, due to COVID, the nurse has to examine everyone prior to entering the jail. Miss Eason stepped out the vehicle.
I'm not Miss Eason.
Miss Wall, my apologies. Miss Wall stepped out the vehicle, and I said, just go ahead to the nurse. And she said some languages I choose not to say via Zoom. And I told her, I said, go ahead and walk over to the nurse. She refused to walk to the nurse. I guided her to the nurse. Once we got to the nurse, she refused to ask questions. And I still had her by the hand because she still wanted to walk. I said, no, ma'am, you have to answer the nurse's question. She began throwing her arms all around the place, and then I had to restrain her. I told Miss Eason on several occasions to stop. I had to request the nurse to go get the deputies inside the jail to come and assist me because Miss Eason was not complying. I never kicked Miss Eason. I never pulled her shirt up so anyone can see her breasts. I simply waited for the deputies to come so I could get assistance.
Just so we're clear, and these extra precautions when Ms. Wall needed to go see the nurse, and that was a result of the safety measures in place due to COVID-19. Is that right?
Yes, ma'am. Prior to entering the jail, the minute they know an officer has arrived with a person that's in custody, they come out. We meet the nurse outside of the doors. After I secure my weapons, I meet with the nurse with my person that I have in custody. They examine them. They ask them all the COVID-19 questions. They put a mask over their face, and then I escort them inside the jail.
How would you describe Ms. Wall's behavior and language during this time?
She was very irate, very belligerent, very disrespectful.
At any time, did she even request to go see the nurse about the minor cut above her lip?
No, ma'am.
Your Honor, I believe that's all I have.
Okay. Do you have any other questions, Ms. Wall?
Yes, ma'am. Ms. Officer Elise, you stated that I threw my hands up.
Pardon?
You stated that I threw my hands up.
I stated I've never put your arms up so the officers could see your breasts. That's what you alleged that I did.
When you were saying that, like, when we first got there, before the officers ever came out, you said that I put my hands up?
Ma'am, I stated, I told you to walk over to the nurse, and you used some languages that I'm not going to state, so I had to guide you to the nurse. You did not want to tell the nurse, pardon?
I wrote it down when you said it, and all I was gonna say is that how can I throw my hands up if I'm in handcuffs?
I never stated you throw your hands up. You stated that I put your arms up, allowing officers to see your breasts once they came out.
How come you didn't documentate my cut? How come you only put Miss Easton's injuries for the judge to read?
I stated that you had a minor cup above your lip. Yes, ma'am.
I'm talking about on the statement that you wrote up prior to me going on court, prior to me going to my first preliminary. Like, how come you didn't documentate my injuries?
Okay, I'm going to object a couple of things. One, when she's saying documentate, I'm not sure what she's trying to say with that. And two, I don't know what writing she's referring to.
When I went to bond court, they stated that I bit Miss Eason, rendering her lip useless. However, they don't say anything about any of my injuries.
Do you want to respond to that, Officer Elise?
Is she referring to the WAA, what was inputted in the WAA?
I think she's talking about when she had her first appearance.
Okay.
Bond court, but I think that's the first. Are you referring to the first appearance, Ms. Wall?
Yeah.
Okay. And so your question is, why was there nothing indicated? So for the first appearance for you, you would only have information as to what you're charged with. You would not have any information as to what, if anything, Ms. Eason was charged with. So you're asking about why they didn't put any information about what the injury was to you. It probably, correct me if I'm wrong, Officer Elise, it probably would be in any paperwork associated with any charge that potentially are coming up against Ms. Eason.
Yes, ma'am.
Yes, ma'am. Also, why do you keep calling me Miss Eason?
I've called you Miss Eason once on accident, and I apologized about that.
You called me Miss Eason when you were arresting me.
No, I did not.
Okay. No further questions.
Okay. Do you have anything else, Ms. Freeman?
No, Your Honor. State rest.
Okay. Okay. Do you have anything? Okay, you cross-examined the witness. You presented your evidence, Ms. Wall. So now we do closing. We do a closing argument. So, is there anything that you feel you need to interject at this time, or are you? What are your thoughts, Attorney Reddick?
Your Honor, Ms. Wall indicated to me that she had graduated law school, and she was taking a bar this month in Georgia. So I am not going to add any of my legal opinion at this particular time because Ms. Wall indicated that she had graduated law school and she knows the law.
Okay.
Basically, I have a psychology degree that I achieved in the U.S. Army. I worked as a psychologist. After that, I got a dual degree consisting of a business and law degree in 2018. I've already paid back my entire student loan. I have to pay for a good faith certificate, which is $1,500, as well as a bar exam. So I greatly appreciate you allowing me to represent myself. I have an 18-year-old daughter. She's in her first year of college as a psychologist. I homeschool my son.
Judge, I'm going to object. Is this part of her closing argument regarding the charges, or is she trying to make an argument for bond? Because we're not here for bond.
Oh, no.
So all of the information that she's giving right now has absolutely nothing to do with what she's charged with.
What I'm saying is, please have mercy on me and pardon me on the grounds of public safety, specifically Georgia Code 16-15-2, legislative findings and attempt, which states that it is the right of every person to be secure and protected from fear, intimidation, and physical harm caused by the activities of violent groups, individuals, Basically, in a case precedent I'd like to state is Star Residential versus Hernandez. I also would like to say COVID-19 ruined my life. I was at home practicing social distancing when my landlord attacked me. I would like to say that it's self-defense due to habitation, Georgia Code 16-3-9, and that's my closing argument.
Okay. Attorney Freeman?
Thank you, Your Honor. We're asking that all of the charges be bound over to Superior Court. Starting with the aggravated battery, Officer Elise testified that when she arrived on the scene and spoke with Ms. Eason, she could visibly see bite marks on Ms. Eason's lip, and her lip was hanging where you could also see her teeth. Ms. Wall in her testimony indicated first that she doesn't know how that happened, and then she said it could have, or she doesn't really remember from what she says biting Ms. Eason's lip. But I believe the testimony from Officer Elise is sufficient to show that Ms. Wall did in fact bite her lip. Ms. Wall, the injuries to Ms. Wall, as Officer Elise described, was a minor cut above her lip. We heard Officer Elise testify about how belligerent Ms. Wall was. She didn't want to talk to the officers. She didn't want to give a statement. She used obscene language. She was kicking in the door. She didn't even want to comply when they got to the Clayton County Detention Center when there were precautions in place for Ms. Wall to meet with the nurse. So, Your Honor, we're asking that the aggravated battery, the obstruction of law enforcement, and the disorderly conduct charges be bound over to Superior Court.
All right, let me explain this. And since you went to law school, you would understand this part of it, Ms. Wall. When the court, in this state proceeding, the court is determining probable cause. And probable cause means that basically the court considers whether an officer has a reason to believe that something has happened, that a crime has happened, and based on that reason, based on that evidence, they would arrest the suspect. That's basically what probable cause is. And so what the court does, the court focuses on the facts and circumstances that would lead a reasonable officer, Officer Elise, to believe that a crime has occurred and that you are the one who committed that crime. So speaking about that in particular, I think what happened when Officer Elise got there is she saw evidence of the way she described this. The injury to Ms. Eason was, I wrote it down, that Eason's lip was hanging by the skin, that because her lip was hanging, she could see her teeth. She was bleeding profusely, and she saw bite marks on her lip. And so based on that evidence, or based on that statement and that testimony from Officer Elise, I do find probable cause for the aggravated battery. Aggravated battery, basically, let me go to that code section. I want you to be sure that you understand everything that this court is doing. 16-524 is aggravated battery. And that's basically a person commits the offense of aggravated battery when he or she maliciously causes bodily harm to another, either by depriving them of a member of their body, by rendering a member of the body useless, or by seriously disfiguring the body or a member thereof. The lip hanging from Miss Eason's mouth, being able to the point where they could see her teeth, that the court would consider that to be a serious disfigurement of her lip. A serious disfigurement would be something that would change the look of that particular part of the body. So I do find probable cause for the aggravated battery. Obstructing an officer, disorderly conduct. Again, with probable cause, Officer Elise, what is reasonable for her to have done, what is reasonable for how she responded to the call, just based on the totality of everything. You indicated that you didn't remember having this altercation with Ms. Eason. It could be that you don't remember the nature of the altercation or how volatile it was, but the court does see and does hear, and I see and hear that this was a very volatile situation, and it seemed like it got more and more volatile as it went on. So I do find probable cause for the obstruction and disorderly conduct. So there's probable cause for all three of those charges. What I did is you said something about the legislative intent. So I looked at that particular code section that you had referred to, which is 1615-2. In that particular code section, it's specifically drawn and focuses on street gang terrorism and the prevention of street gang terrorism. And so when it says the General Assembly finds it's the right of every person to be secure and protected from fear, intimidation, and physical harm, that's caused by the activities of violent groups and individuals. And that basically speaks to anyone who may be a victim of a street gang, a victim of terrorism. That's what that particular code section speaks to. But you're right, everyone does have a right to be free from any type of harm, and they have a right to be free in the exercise and the quiet enjoyment of their home. That applies to you, Ms. Wall, but it also applies to Ms. Eason. And so I don't know what she's been charged with. I don't know where she is in the whole process, but certainly if there's any evidence that speaks to any injuries that happened to her, the court will look at that in conjunction with everything that you provided today and make sure that she gets the same due process that you're going to get and that you've gotten.
So we're not going to view the arrest videos to verify if the statements Officer Elise made are true?
So we don't do that. So today is the first hearing in a set of hearings. And there's going to be an opportunity during the discovery process, which is what will kick in now. The discovery process was when your attorney or yourself will request the videos, request any evidence that you feel would be exculpatory towards you, would help you with your case. And so that's when we move into those videos and anything else that you think would be, pertinent to any defense that you're positing right now. But for purposes of the probable cause hearing,
Okay, thank you.
It's not totally required that I see the video.
Okay, and Sherry doesn't have to come at all?
It's the officer can testify as to what she said, what she saw, what she said being what Ms. Eason said, what she saw when she responded to the scene. And at some point, you certainly have a right to talk to through your attorney or yourself, to talk to Ms. Eason and to see, the validity of her statement and her testimony and any evidence that she provided. You have a right to that. But for right now, it's you. It's the state versus you, Ms. Wall. It's not the state versus Ms. Eason for this particular hearing.
So do I have the opportunity to press charges for being robbed? Because I don't know where any of my stuff is.
That's a civil case, and that would be something else that you probably would need to get somebody to advise you with. What your civil remedies are, any type of civil action that you may have legally to decide if there's anyone that is responsible or negligent in this entire matter, and then to make that determination as to who you want to pursue. But for purposes of this hearing, this is done. Ms. Wall, what is Ms. Wall's bond right now?
Let me check, Your Honor.
Because that needs to be the next focus, Ms. Wall. You've been in jail since August.
It has my hold been lifted?
Okay, let's come off YouTube. There's a hold on you. Is that from another jurisdiction?
From
Yes, Your Honor.
And
I'm gonna come off YouTube because I don't want, Ms. Wall, I don't want all of the information relevant to you to be.
I pay my bond and still can't get out.
She has a bond on all of her charges. She has a $10,000 bond on the ag battery, and she has $1,500 on the obstructing and a $1,500 on disorderly conduct.
Okay. So is the state, let's talk about. All right, we are live on YouTube now. And we are here in the matter of the state versus Xavier Scott. Here for the DA's office, Senior Assistant District Attorney Cheryl Freeman, representing the state. Attorney Thomas Florio, representing Xavier Scott. Detective Andrew Chapman for Clayton County Police Department. And I'm Judge Dallas, sitting by designation of the Superior Court of Clayton County. Let me swear you in, sir. Do you swear or affirm the information you give, any testimony you provide in the matter of the state versus Xavier Scott is the truth, the whole truth, and nothing but the truth, so help you God? I
do.
Okay, thank you. Your witness.
Thank you. Detective, please tell us your name and how you're employed.
Detective Andrew Chapman. I'm employed with the Clayton County Police Department in the Criminal Investigation Division, Major Felony Unit.
Detective, how long have you worked with the Clayton County Police Department?
I've worked with Clayton County Police for approximately 9 years.
And how long have you worked in this particular unit?
Approximately 4 years.
Detective, were you working with the Clayton County Police Department on August 17th of 2020?
I was.
On that particular day, were you assigned an investigation in reference to a person being shot at 7545 Kevin Place?
I was.
Did you go to that scene on that day?
I did.
When you arrived on the scene, tell us how your investigation started.
I arrived on the scene after the uniform division was already there and had the scene secured. Mr. Xavier Scott was detained by the uniform officers at the scene and in a patrol vehicle, and they had the scene taped off. We determined that there was a couple vehicles in the driveway and a male who was deceased on the front porch. He was later identified as Taylor Smith.
Were you able to determine at that point how many bullet wounds Mr. Smith had?
There were 3 shell casings on the scene, and he appeared to have 2 defects to his torso. We believed at least 2 gunshot wounds.
Could you tell if he was shot from the front or the back?
It appeared that they were coming from the front.
Were you able to speak to witnesses there to figure out what happened?
I was able to speak with some of the neighbors that had some video surveillance. There were no direct eyewitnesses to the altercation, but one next door neighbor had had cameras and that had 2 different views that showed one of the vehicles that was parked in the driveway, which we believed was a black Audi Q5. It was registered to Mr. Smith. One of the video cameras showed that vehicle pulling down the cul-de-sac, stopping in front of a neighbor's house. Mr. Smith exited the vehicle and he appeared to be on the phone. And then he re-entered his vehicle, turned around in a driveway, and then pulled straight down to park in the driveway of the incident location. The other camera view showed Mr. Smith as he walked up the driveway to the front porch of the house. It didn't show any portion of what happened on the porch, but it showed him walking up the driveway.
Whose residence is this at 7545 Kevin Place?
Mr. Scott and his family.
Is this a single family home?
It is.
It is, okay. Detective, after reviewing the video surveillance footage of the neighbors, were you able to kind of ascertain what happened regarding this shooting?
We later had, shortly after that, we had the uniform officers transport Mr. Scott to our headquarters building, where myself and another detective did a recorded interview with Mr. Scott, and he was able to tell us the whole story of what occurred.
What did Mr. Scott indicate that occurred?
So Mr. Scott advised that he knew of Mr. Smith. They went to the same high school. That Mr. Smith was currently dating a woman named Tiana Lewis. who Mr. Scott identified as his best friend, a lifelong friend since high school. He said that he learned the day of the incident that earlier in that same day, Miss Lewis and Mr. Smith got into a
All right. Detective Chapman.
in Atlanta at Mr. Smith's residence.
Okay. 1 second, Detective Chapman. Detective Chapman.
Yes, ma'am.
You went out after you talked about Mr. Smith was dating Tiana Lewis, and that's the last that I heard. And at that point, you went out. So that I don't know if anyone heard anything.
I'm sorry.
That's the last I heard, is that you found out that Mr. Smith was dating Tiana Lewis.
Mm-hmm.
And after,
Sure.
There's nothing else.
So, can you hear me now?
Yes.
Okay. So, Mr. Scott advised that Mr. Smith was dating Tiana Lewis. Tiana Lewis is a lifelong friend of Mr. Scott's. He advised that earlier that same day, Miss Lewis and Mr. Smith got into a physical altercation at Mr. Smith's house in Atlanta. After he found out about that, he contacted Mr. Smith via Facebook and sent him a message saying that he was displeased with the altercation, with finding out about the altercation. The two men then engaged in a argument via this Facebook messaging app. During that altercation, or during that argument, Mr. Smith advised Mr. Scott multiple times to meet him somewhere. It appeared to be for the purposes of a physical fight. Mr. Scott did make some threats of violence, saying things like if he came to his home, if Mr. Smith came to Mr. Scott's home, Mr. Scott would shoot him. Later, Mr. Smith asked Mr. Scott where he lived, and then Mr. Scott sent him his address, the 7545 Kevin Place address. Mr. Smith then sent a confirmation message saying that he was coming. Once he arrived, he sent another message saying that he was there and told him.
Okay. He's gone again.
You broke up a little bit. The last part I heard is when Mr. Smith sent a message that he was at the residence. Was the last thing I heard.
Okay. Yes, ma'am. So Mr. Smith told Mr. Scott that he was at the residence. Mr. Scott then sent a final message to Mr. Smith saying, "Park in the yard." After that, Mr. Scott advised that Smith got out of his vehicle, approached the house. I asked Mr. Scott if he saw Mr. Smith armed with any weapons or had any belief that he was armed with any weapons. He said that he saw Mr. Smith pat his pockets, but that he never saw him armed with anything, never saw anything in his hands. He said when Mr. Smith approached the porch, Mr. Scott was already outside with his weapon in his hand. It was a Glock 17 pistol. Mr. Scott then told Mr. Smith to leave. Mr. Smith asked Mr. Scott if he was going to shoot him, and then said, "No, let's fight." And then Mr. Scott advised that he fired at least twice at Mr. Smith.
And just so we're clear, because I may have missed it. So who asked whom if they were going to shoot him?
Mr. Smith asked Mr. Scott, "Are you going to shoot me?" Mr. Scott then said that Mr. Smith said, "No, let's fight."
After those words were spoken, at that time, Mr. Scott then shot Mr. Smith twice. Is that
correct?
Did Mr. Scott say at any time that Mr. Smith pulled out a weapon?
No.
were you able to view the messages on Facebook Messenger between
Yes, ma'am.
Mr. Scott and Mr. Smith?
Yes, ma'am.
Were you able to locate the firearm that Mr. Scott used?
Yes, ma'am.
Was that still, I guess, at the scene when you got there?
It was inside the house.
Did the decedent have any weapons on him?
No, ma'am. None on his person and none in his vehicle.
Detective, you had indicated that from the surveillance videos that you could see the decedent, Mr. Smith, on the phone at one point, and then you could see him, I guess, pull up in the driveway of the home. Were you able to determine if the time when you saw him on the phone in the video, did that correspond with the time of the messages between the defendant and Mr. Smith?
It appeared to. The timestamps on the videos were not correct. So it's hard to say for sure, but it appeared to link up somewhat directly with those.
Okay. All of this happened in Clayton County?
It did.
Was anyone else in the residence during this time?
No, ma'am. No, nobody else.
Thank you. I believe that's all I have.
All right, Cross, Attorney Florio.
Yes, ma'am. Thank you, Your Honor. Good morning, Detective Chapman.
Good morning.
Now, you'd agree with me, Detective Chapman, that Clayton County Police were not the first ones on the scene of this incident. Is that correct?
Yeah, I believe the Sheriff's Department was the first law enforcement there.
Okay. And during the course of your investigation, did you have an opportunity to speak with Investigator Griffin from the Clayton County Sheriff's Office?
No, I haven't.
All right. Have you had an opportunity to view an evidence sheet prepared by Officer Griffin of the Clayton County Sheriff's Office?
No.
During the course of your investigation, did Investigator Griffin of the Clayton County Sheriff's Office tell you that he found a 9mm Luger firearm on Mr. Smith's body?
All right, I'm going to object. Detective has indicated that he hasn't spoken to an Investigator Griffin with the Clayton County Sheriff's Office.
I'll strike that, Judge. Yes, ma'am, I'll strike that. All right. During the course of your investigation, did you learn that the victim had a 9mm firearm, a handgun, on his body?
No.
Okay. During the course of your investigation, has anybody from the Clayton County Sheriff's Office made you aware that they have a 9mm firearm in their custody related to this incident?
No.
Okay. Has anybody made you aware? Well, strike that, Your Honor, strike that. Okay. So let's go back. So during the course of your investigation, you were made aware that earlier in the day, there was a difficulty between Taylor Smith, the victim, and Tiana Lewis. Is that correct?
Yes.
Okay. And what were you told? What was that incident? What had occurred?
There was some kind of physical fight that occurred at Mr. Smith's home in Atlanta.
Okay. And would that be with Mr. Smith being the primary aggressor in that incident towards Ms. Lewis?
It's hard to say. There's two different stories related to that.
Okay. Who have you talked with regard to that story? To those stories,
Ms. Lewis?
Okay. And when did you speak with Ms. Lewis?
It was after this incident occurs, probably the next week.
Okay. And what has Ms. Lewis told you about this?
About this incident or the one in Atlanta?
Let's start first with the incident in Atlanta, the incident between her and Mr. Smith. What did she tell you?
Well, Judge, wait, I'm going to object because, and I believe what I've heard is that this is an incident that happened earlier in Atlanta. It was not in Clayton County. It was not at the scene of this 7545 Kevin Place. So at this point in time, for purposes here, I'm going to say that it's not relevant.
Judge.
Response?
Yes, ma'am. I would argue first, the state went into this on their direct examination. This isn't something that I opened the door on, but this is something that Ms. Freeman and Detective Chapman went into on to indirect. Also, Judge, I think it's relevant to the extent that it's what created the situation that ultimately occurred. It's the basis and the foundation is Officer.
You froze.
Mr. Smith. So I believe it's completely relevant.
You froze, Attorney Florio.
Is it better?
It is.
Where did I lose you, Judge?
You said that basically you thought it was relevant because it goes into the relationship between Smith and Lewis. And that's the last I heard. And now he...
Uh-oh.
Am I frozen?
You froze again.
You were. You were.
Judge, will you give me 2 seconds to just walk across my office next? I'll position myself right next to the router.
Okay,
It'll
great.
take me 2 seconds.
Yes, sir.
Okay. I apologize, Judge.
No worries.
Okay. Has Your Honor made a ruling on the objection?
Well, I believe that the state did open it because I wrote down here earlier that day they got into a physical altercation, Tiana Lewis and Mr. Smith. So I think that the state opened the door. That will allow you to have a thorough and sifting cross-examination as to the point. I overrule the state's objection.
Thank you, Your Honor.
Thank you, Your Honor. And so, Detective Chapman, I understood you to say that Ms. Lewis had given 2 different versions to you. Is that correct?
No. Ms. Lewis gave one version and there's some text messages.
What was the version that Ms. Lewis gave you?
Ms. Lewis said that she went to Mr. Smith's home in Atlanta to discuss their relationship. During that, an argument ensued. The argument became physical and she was left with some bruises.
Okay. And when you spoke with Ms. Lewis, did you observe bruises or was it too far removed from the actual incident itself?
I didn't observe any bruises, no.
Okay. When you spoke with Ms. Lewis, was she able to provide any information regarding the incident between Mr. Scott and Mr. Smith?
Not much more than was already known at that time. She obviously wasn't there at the time. She knew of the prior incident with her and Mr. Smith. She knew of the argument between Mr. Smith and Mr. Scott via Facebook. Mr. Scott was also in a text message chain with Ms. Lewis discussing the argument. And Mr. Scott was actually on the phone with Ms. Lewis when Mr. Smith arrived, but she said she didn't hear anything specific to what anyone said.
Okay. What did she tell you with regard to her being on the phone? So she was on the phone with my client when Mr. Smith arrived at his house. That's correct?
Yes, sir.
Okay. And what did Ms. Lewis tell you about the conversation that she had with Mr. Scott when Mr. Smith arrived at the home?
She didn't say that she heard anything that occurred between them. so she couldn't add much to what happened.
Did she give you any statements made by my client, Mr. Scott?
No, I don't believe she did.
Did she relay the context of the conversation or the content of the conversation that she and Mr. Scott were having when Mr. Smith arrived at his home?
Basically, she said that she was trying to tell Mr. Scott not to do anything. They had a previous text messaging that was going on where Mr. Scott was telling her that that he and Mr. Smith were arguing. He told her that if Mr. Smith came to his home, he was going to catch nothing but bullets. Miss Lewis told him not to do anything and to let the police handle it. She actually begged him emphatically several times in the text messages not to do anything.
Okay. Do you have those text messages between Mr. Scott and Ms. Lewis?
I do.
Okay. Who were they provided by, or were they obtained via subpoena?
They were provided initially. There were screenshots from Mr. Scott himself during our interview, and then later during a search of his phone, we were able to recover them again.
Okay. And so this started, I understood you to say that this started with communication between Mr. Scott and Mr. Smith via Facebook. Is that correct?
That's correct.
Okay. And whose Facebook accounts was this communication between?
Mr. Scott's and Mr. Smith's.
Okay. All right. And at some point, I understood you to say that there was communication from Mr. Kind of indicating that if Mr. Smith came to his home, that there would be an incident, that there would be some sort of difficulty between them. Is that correct?
I'm sorry, could you say it one more time?
Yes, sir. I understood you to testify that there was a message from Mr. Scott to Mr. Smith early on telling him, don't come to my home. Is that correct?
Basically, yeah, I agree with that.
Okay. All right. And you'd agree with me that you've had a chance to review the video of the neighbor's video surveillance. Is that correct?
Yes, sir.
Okay. And you'd agree with me that the black Audi drives down the street and then circles the cul-de-sac in which my client's house is located and then drives back down the street. Is that correct?
Yes.
Okay. And you'd agree with me, my client's house is kind of on the far end of a cul-de-sac. Is that correct?
Yes, sir.
Okay. You'd agree with me at that point that Mr. Smith then parks his black Audi on the street facing away from my client's house. Is that correct? I'm sorry, you're saying before he pulled down the cul-de-sac? Mm-hmm. Yeah, like he drives around the cul-de-sac and then drives back down the street as if he's leaving. Is that correct?
Yes. Yes, that's correct.
And then he stops his car and parks on the side of the road. Is that correct?
Yes.
Mr. Smith then gets out and opens his back door. Is that correct?
Yeah, I believe so.
Okay. Mr. Smith seems to linger for maybe about 25 to 30 seconds outside of his vehicle. Is that correct?
Something like that. Yes, sir.
Okay. Mr. Smith then pulls into a neighbor's driveway, backs out, and then drives back down the street a second time towards my client's house. Is that correct?
That's correct.
Okay. And that's when Mr. Smith pulls into my client's driveway. Is that correct?
Yes, sir.
Okay. You'd agree with me that Mr. Smith had no property interest in my client's home. Is that correct?
Yes, sir.
Okay. It's not his house. He didn't live there, wasn't renting anything, nothing of that nature?
Correct.
Okay. You'd agree with me that Mr. Scott opens the front door to his home. Is that correct?
Yes.
Okay. And you'd agree with me at that time that Mr. Scott had a firearm in his hand. Is that correct?
That's correct.
Okay. Mr. Scott told you that he showed the firearm to Mr. Smith. Is that correct?
Yes.
Okay. And you'd agree with me that Mr. Smith walked up the entire length of the driveway from down near the street all the way up to the garage of the house, correct?
Yes.
Okay. And you'd agree with me that Mr. Smith then would have had to have walked basically 2/3 of the way across the front of the house, down a walkway towards the front door. Is that correct?
Yes, I'm not sure about the exact length, but yeah, he walked to the front porch, yes.
Okay. You'd agree with me that he would have had to have taken a step up onto the front porch. Is that correct?
Yes, sir.
Okay. And you'd agree with me that it was that, did you have an opportunity to view Mr. Smith's body at the scene?
Yes, sir.
Okay. And is it your understanding that Mr. Smith's body was found actually on the front porch in front of the front door to the home?
No, he was on the ground between the front porch and the bushes. It looked like he fell on the porch and probably rolled off the porch somewhere. So how far onto the porch, I couldn't say.
Based upon your investigation, it appeared that at some point Mr. Smith had been on the front porch, but it may be fallen off the front porch back onto the walkway.
Yes, it's possible.
That's speculation.
Okay, I'll start that.
So I would have sustained the objection as speculative.
How big, from where you would step up on the front porch to the front door itself, were you able to view that area?
Yes, sir.
Okay. How many feet is it from where you step up onto the front porch to the front door of the home? How many feet was that?
It's approximately 10 feet, something around there.
Okay. And so based upon your investigation, you can put Mr. Smith at least within 10 feet of Mr. Scott's front door. Is that correct?
Yes.
Okay. You'd agree with me that Mr. Scott told you that he told Mr. Smith to leave. He verbally gave him that admonition to leave. Is that correct?
That's what he told me. Yes, sir.
Okay. And you'd agree with me that Mr. Scott told you that he showed Mr. Smith the firearm. He brandished it and showed him that he had a gun in his hand, correct?
Yes, sir.
And you'd agree with me that according to Mr. Scott, Mr. Smith's last words were "No, let's fight." Is that correct?
That's correct.
And you'd agree with me that immediately, and those last words, did Mr. Scott tell you where Mr. Smith was located when those words were uttered towards him, when that threat was made towards him?
I believe he said that Mr. Smith was like at the entrance of the porch and Mr. Scott was at the door of the house.
And you'd agree with me that after uttering the phrase, "Now let's fight," that's when Mr. Scott intimated to you that he discharged his firearm. Is that correct?
That's correct.
Okay. You'd agree with me that Mr. Scott was the one who called 911. Is that correct?
Yes, sir.
Okay. Have you had an opportunity to listen to the 911 call?
I have not.
Okay. You'd agree with me that Mr. Scott then placed his firearm inside of his home in the kitchen area. Is that correct?
Yes, sir.
Okay. You'd agree with me that he told law enforcement where the firearm was located. Is that correct?
Yes, sir.
Okay. You'd agree with me that Mr. Scott made no attempts to conceal the death of Mr. Smith. Is that correct?
That's correct.
You'd agree with me that Mr. Scott made no attempts to try to flee the scene. Is that correct?
That's correct.
You'd agree with me that Mr. Scott made no attempts to try to obstruct law enforcement's investigation. Is that correct?
That's correct.
Okay. The statement that Mr. Scott gave to you at the Clayton County, that was done at the Clayton County Police Headquarters. Is that correct, sir?
That's correct.
And I understood you to say that it was you and there was another detective that was present for that interrogation. Who was that other detective, Detective Chapman?
Detective Cooper.
Okay. And who would you identify as being the lead detective on this case?
I am.
Okay. Are you familiar with all aspects of this investigation?
As it stands now, it's still ongoing, but yes, what's been done so far, yes, sir.
Okay. But just so I'm clear, you've had no communication with the Clayton County Sheriff's Office regarding the initial investigation into this case. Is that correct?
No, I did not interview them, no.
Okay. Now, the statement that Mr. Scott gave to you at headquarters, was he Mirandized?
Yes, sir.
Okay, and when was he read Miranda? Before or after the interrogation began?
Before.
Okay, and was there a written waiver of rights form?
Yes, sir.
Okay, and was the interrogation, was it audio and video recorded?
It was.
Okay. Are you familiar with did Mr. Scott give any statements to to initial Clayton County police officers who arrived? I presume they would have been uniformed officers?
Yes, sir.
Who were those uniform officers, police detective?
Be an Officer Stinfield and the Officer Stinfield and Officer Bice.
Okay. Okay. Now, I understood you to say that you reviewed video from one of the neighbors' video surveillance. Is that correct?
Yes, sir.
Who is that neighbor? What's that person's name?
It's Tobias Martin.
Okay. And do you have a copy of that video recording? Did Mr. Martin provide it to you, or have you recorded your own version of it?
Yes, sir. I've got one for evidence.
Okay. And how did you obtain that?
From his video surveillance system.
Okay. There are other neighbors located on this cul-de-sac. Is that correct?
Yes, sir.
Okay. And as part of your investigation, did you attempt to speak with any of those neighbors?
Yes, sir.
Did you speak with a gentleman named Eustace Brandy? That's Eustace, last name Brandy, Brandy. Did you speak with Mr. Brandy?
I don't recall that name, no.
Okay. Did you speak with a neighbor who reported having seen Mr. Smith's black Audi parked in front of my client's house the night before this incident?
I was told that information by Mr. Scott's mother. I followed up a second time and canvassed the entire street and couldn't find anyone that could confirm that information anywhere.
Okay. Did you speak with a young lady named Brianna Turner? That's Bryonna, last name Turner, common spelling Turner. Did you speak with Ms. Turner?
Yes, I believe some other detectives that were doing the initial canvass spoke with her at the scene.
Okay. Who were those detectives that spoke with Ms. Turner?
It's a Detective Stoika and Detective Detective Stoika and Detective Solomon did part of that canvass the day of.
Okay. Okay. Just 1 second, please, Your Honor.
Absolutely.
During the course of your investigation, did you speak with a gentleman named Brian Lewis?
I'm sorry, say the name again.
I apologize. Did you speak with a gentleman named Brian Lewis? That's Tiana's brother.
No.
Okay. Were you ever told how Mr. Scott was made aware of the fight between Mr. Smith and Ms. Lewis?
So Mr. Scott said that Miss Lewis told him. Miss Lewis said that she believed Mr. Smith told Mr. Scott. But in searching Mr. Scott's phone, it appears that Brian Lewis sent out a group text message to several people advising them what happened.
Okay. Now, independent of this incident, do you have any evidence or any information as to when the last time Mr. Scott and Mr. Smith had spoken prior to the date of this incident, August the 17th?
From Mr. Scott's interview, he advised that basically they had no contact. They knew each other from high school. During the search of the phones, the only contact that I could find was related to this specific day.
And you'd agree with me that Mr. Scott and Mr. Smith would have been in high school some time ago, literally years ago. Is that correct?
That's correct.
Okay, not in the last 5 or 6 years. Do you believe there were any? You don't have proof of any communication between Mr. Smith and Mr. Scott? Is that correct?
That's correct.
Okay, and so no other prior difficulties, no other issues, nothing of that nature. Is that correct?
Nothing that I've found so far.
Okay. Just one more second, please, Your Honor.
Absolutely.
Now, going back, when you spoke with Mr. Scott, did Mr. Scott intimate to you, referencing the video, okay, you agree with me, as we said earlier, that the video shows Mr. Smith pull down the street, circle the cul-de-sac, and then drive back down the street before the incident, correct?
Yes, sir.
Okay. And when you spoke with Mr. Scott, did he tell you that that path, that circling circling the cul-de-sac in front of his house, that at that time he had told Mr. Smith to keep on going and don't stop?
He indicated that he walked outside and yelled that at the vehicle. There's no messages that confirm that. All the messages is him inviting Mr. Smith onto the property.
Okay. And you'd agree with me that at the time that this occurred, Mr. Scott was on the phone with Tiana Lewis. Is that correct?
That's what he advised, yes.
Okay. Well, I mean, but Tiana told you she was on the phone with Mr. Scott,
yes.
Correct? Okay. And so when you testified earlier that Mr. Smith was on his phone prior to this incident, we can all agree that he more than likely, based upon the testimony or the statement of my client and Ms. Lewis, and based upon your investigation, you'd agree with me that Mr. Smith was not communicating with Mr. Scott. Is that correct?
I'm going to object because that's going to be speculation.
That's counsel response.
Well, he's testified that he's reviewed all the messages. He's testified that he spoke with Ms. Lewis. He's testified that Ms. Lewis told him that she was on the phone with Mr. Scott when this incident occurred. He's testified he reviewed the phone records. He's got my client's phone records, he testified. So I don't think it's speculation. I mean, he's reviewed the records. He testified to what the records reflect.
Attorney Freeman?
Your Honor, I still think it's speculation for this detective to be able, because what Mr. Florio wants him to say is that the decedent could not have been on the phone with the defendant at the time, but we don't know that.
I'm not going to go into how possible it is and how probable it is, because then it makes me speculate as to how this happened. So you can't ask the detective. You can simply say what you're saying here, what your argument is here. This person was on the phone with this person, was on the phone with this person. But you can't ask Detective Chapman to make any type of reference or inference or speculation as to who wasn't on the phone. So I'm going to agree. It's a thin line. You're splitting hairs here, counselor. So I'm going to agree that it's speculation.
Detective Chapman, have you reviewed Tiana Lewis's phone records?
No, sir.
Okay. But Tiana Lewis told you that she was on the phone with my client when this incident occurred. Is that correct?
Yes, sir.
Okay. And do you have, based upon your investigation, do you have any reason to believe that Tiana Lewis has lied to you?
No.
Okay. And you've not charged Ms. Lewis with lying to you. Is that correct?
That's correct.
No further questions, Your Honor.
Does the state have any redirect?
No, Your Honor. State rest.
State rest. Attorney Florio, any witnesses?
No, Your Honor.
Okay. Argument?
Well, the state waives opening, Judge.
Okay, Attorney Florio?
Yes, ma'am, Your Honor. Your Honor, we'd ask that the court not find probable cause for these charges. The testimony is clear that there was a prior difficulty between Mr. Smith and Ms. Lewis. Okay, Mr. Scott was made aware of that prior difficulty, and there was communication via Facebook between Mr. Scott and Mr. Smith. But the testimony is also clear, Your Honor, from Detective Chapman and these are messages that he viewed, that at some point my client told Mr. Smith, "Don't come to my house. If you come to my house, there's going to be issues." That's uncontroverted. And we now know that there's a story going around that the alleged victim, Mr. Smith, had driven by my client's home the evening before this all occurred. We know that the evidence would show that Mr. Smith pulled down the street, that Mr. Smith circled the cul-de-sac in front of my client's house, that Mr. Scott told the police that at that point he brandished his firearm and told Mr. Smith to keep on going, that Mr. Smith pulled down the street, got out of his vehicle, opened his back door, I would suggest to retrieve a firearm, that took 25 to 30 seconds, where Mr. Smith has the back door of his automobile open, is rummaging around, closes it, gets back in his automobile, pulls into the driveway of a neighbor's home, backs out, pulls into my client's driveway. The testimony again is that my client again shows Mr. Smith, "I have a gun." That my client tells Mr. Smith, "You need to leave, you need to go." That Mr. Smith walks up the entire length of my client's driveway, that Mr. Smith walks across the entire front of my client's house, that Mr. Smith steps up on my client's porch, all the while my client holding a gun telling him leave. And the testimony of Detective Chapman being that Mr. Smith's last words were, "Now let's fight." And my client shot him twice. My client didn't try to flee the scene. My client didn't try to obstruct an investigation. My client called 911. My client placed his firearm inside his home. My client waited for police to arrive. My client went to headquarters with Detective Chapman. My client gave a statement to Detective Chapman. My client gave his phone to Detective Chapman. My client made his Facebook messages and his call log available to Detective Chapman. There's nothing that my client did that's inconsistent with the fact that this young man was protecting himself in his home. And the testimony that, well, he sent messages and he told Mr. Smith where he lives. Well, there's a story, evidently we know now, there's a story going around that Mr. Smith had cased my client's house the evening before, had driven by my client's house the evening before. And even if my client said, "Come over," okay, even if my client said come over, Judge, there's nothing in the law that says that he can't revoke that consent. That at some point, if he makes the decision, "I don't want you here anymore, I don't want you to be at my home anymore," there's nothing that says that he can't. And when he's telling this young man, "Leave, go on, don't," and the young man walks up his driveway, crosses the front of his house, steps up on his porch, with his last statements being, "Nah, let's fight." Judge, at that point, my client had every right to defend both himself and his property. And the fact that Detective Chapman has not spoken with investigators with the Clayton County Sheriff's Office, and the fact that Detective Chapman has not ascertained whether or not there was a Ruger 9mm taken off of the decedent's body, or whether or not there's an evidence sheet that suggests that there was a Ruger 9mm taken off the decedent's body, that's not my client's fault that investigation hasn't been done, and that Chapman hasn't talked to the initial officers that responded to the scene, and hasn't talked with the initial officers that got my client's firearm out of the house. That's not my client's fault that testimony isn't here today. And so based upon that, Your Honor, I would ask that these charges be dismissed against my client. Thank you.
Judge, okay. A couple of things. And I know Attorney Florio, he referenced a couple of times about the decedent, casing the home or being there the night before. That was no evidence. Attorney Florio asked the detective about if he had gotten information about whether or not the victim had driven past the home the day before. The detective's testimony was that the defendant's mother had mentioned that, but when the detective went canvass the neighborhood to ask if anyone had seen that, he didn't get any information to corroborate that. So that was not something that that was in evidence. And my argument is that based on the messages that Detective Chapman reviewed, this defendant planned to shoot this victim. Detective Chapman indicated there has been an investigator, Griffin, I believe that was the name, has not reached out to the detective. The detective does not have any information about the sheriff's office conducting an investigation. Detective Chapman testified there was no firearm that was found on the decedent. In fact, he said that the defendant even stated that he did not see a firearm on the decedent. So, Judge, and certainly if this goes to trial, if Attorney Florio makes the argument of self-defense, well, that's for the jury trial. But at this stage, the evidence that Detective Chapman has testified to, this defendant threatened the decedent, that he indicated, I believe, that if he came to the home, that he would have bullets in him. He planned to shoot him. And so we're asking that all of these charges, the murder, the aggravated assault, and the possession of a firearm during the commission of a crime be bound over to Superior Court.
Okay. So at this juncture, probable cause just basically requires the court have to consider whether the officer had a probable cause reason to arrest a suspect. So what I focus on facts and circumstances that will lead a prudent person, a reasonable officer, to conclude that the suspect probably has committed an offense. And at this point, I do find that there's probable cause to bind all three of these charges up to the Superior Court of Clayton County. And I think at that point, if there's any other arguments that the Attorney Florio wants to possess, or not to possess, but to present, then that will be the time to present those particular arguments. For this state of the proceeding, I do find that there is probable cause for all three of these charges. That would be the murder, the aggravated assault, and the possession of a firearm during commission of a felony. Thank you.
Thank you, Judge.
Yes, ma'am, Your Honor. Thank you, Judge.
Okay.